In this module, we will discuss about custom valuation and dispute settlement. Custom valuation is the process where custom duties are levied by the custom authorities on the value of goods or services imported. The customs authorities adopted the system as a means of protecting tariff concessions, implementing agreed trade policies, collecting revenues, and protecting the health and safety of the people of the country. The Article 7th of the GATT outlines the provisions and procedures for the valuation of the goods and services and is applicable to all the members of the World Trade Organization. Custom valuation aims at determining the customs value of the imported goods or services in a fair, neutral and uniform way that conforms to the commercial realities by preventing the applicability of arbitrary or fictitious customs value for levying the duty rates. The agreement was initially negotiated a common customs valuation system known as GATT Valuation Code at Tokyo Round, where the large majority of the developing countries choose not to accept it due to the controversies between developed and developing countries for customs valuation. In the end, the developed and developing countries arrived on compromising their differences, adopted the agreement in the Uruguay round negotiations. The WTO Committee on Customs Valuation has been vested with the powers to administer the agreements. A technical committee on customs valuation was also established with the view of ensuring fair and uniform interpretation and applicability of the agreement at wider level. The starting point for customs valuation under the agreement is transaction value as defined in Article 1st describing the price actually paid or payable for the goods when sold for export to the country of importation. Article 1 read with Article 8 of the agreement allows the customs authority to adjust the price actually paid or payable in cases where certain specific elements form the part of value but not included in the price of the imported goods. Article 8 also allows determining the transaction value by including the value of certain considerations which may transfer from seller to buyer in the form of specialized goods or services rather than in the form of money. There are two types of methods on which the import duties are calculated. First, specific basis. Under the system, a fixed amount of duty rate is charged on the basis of quantity of goods imported, such as 0.1 cents per liter of imported oil. Second, ad valorem. Under the system, the duty rate is expressed as a percentage of the value of transaction of goods imported. Third, compound basis. The duty rate on certain imported goods may be the combination of specific and ad valorem rates. Nevertheless, ad valorem are most prevalent in international trade as they are used by the WTO members. Now, the question arises on what basis the customs official determine the value of goods and services is of great importance for the importer, similar to the rates of duty specified in the tariff schedule for the goods. Presently, the rules for determining the value of imports for levying customs duties are well organized and elaborated one and are outlined in the WTO Customs Valuation Agreement. After reading this module, you shall be able to understand the concept of customs valuation, know about the methods of customs valuation, analyze the preferential treatment to developing countries, understand the dispute settlement procedure of WTO. Now, let us understand about the methods of customs valuation. These methods of customs valuation are applicable for the cases where there is no transaction value or where the transaction value is not acceptable as the customs value. because the price has been distorted with the outcome of certain conditions. 6 methods have been specified to determine the customs value of goods or services as discussed below. Transaction value, the total price paid or to be paid by the buyer to seller or to benefit the seller for amount of imported goods and consist of all proceeds made as a condition of sale by the buyer to seller or to the third party on the direction of seller to meet the obligation. The customs value would be considered as transaction value if all the conditions mentioned below are satisfied. A. There must be an evidence of sale, that is, invoices, contracts, purchase orders, etc. B. There must be no constraint on the usage of goods imported by the buyer other than constraints which are imposed by the country of importer, where the goods are limited to geographical area and do not affect the value of the goods substantially. C. The contract or sale must not be subject to certain conditions or considerations for which the authorities cannot evaluate the true value of the transaction. The examples of this condition may be like any one or in combinations of them are as follows. Where seller puts the conditions on buyer to buy other goods in specified quantities from him where the price of the goods imported are based on the other goods that buyer charged from seller and where amount is charged on the basis of a form of proceeds inappropriate to the imported goods. D. There shall not be adjustment or accrual directly or indirectly to the seller with respect to any subsequent resale, use or disposal of the goods by the buyer. E. There must be an existence of sufficient information for adjustment to be made to determine the transaction value such as commissions and brokerage except buyer commission, packing and container cost and charges, assessed royalties and license fees, subsequent proceeds, cost of transportation, insurance and other related charges based on CIF basis and do not include after import expenses incurred on the goods. F. That the buyer and sellers must not be related with each other. They are found to be related with each other in the following circumstances, such as they are the office bearers or directors of each other institution. They are partners, employer-employee, hold 5% of voting rights or shares directly or indirectly. Both of them are controlled by third party or they are the members of the family. Transaction value of identical goods. The value of transaction is measured cannot be determined on the basis of Article 1. Then the next method is to evaluate the goods on the basis of identical merchandise if the goods are same in all respect except minor differences such as physical characteristics, quality, reputation of the goods under consideration or produced in the same country, manufactured by the manufacturer of the goods being valued if available, sold for export to the same country of importation and exported at or about the same time for evaluating the value of goods. While following this article, the transaction value of identical goods of the same commercial level with same quantity shall be value of transaction value of goods concerned. Where there is non-availability of sale of such identical goods, the value at different commercial level with different quantities can be considered for such valuation provided the differential attributable to commercial level and or the quantity shall be used. Such adjustments can be provided on the basis of evidences clearly depicting the reasonableness and accuracy of the adjustment. For the applicability of this method, two or more transactions of identical goods are required to be identified and the lowest such values shall be adopted for deciding the transaction value of goods imported. Transaction value of similar goods. If the transaction value cannot be determined on the basis of Article 1 and 2, the transaction value of imported goods is measured on similar goods if goods are component material and characteristics is resembling. Goods are capable of performing the similar functions and are commercially interchangeable with goods being valued. And goods are produced in the same country and by the producer of the goods being valued. For this, the goods must be sold for export to the similar country of importation and exported at or about the same time for determining the value of goods. While following the article, the transaction value of similar goods of the same commercial level with same quantity shall be value of transaction value of goods concerned. Where there is non-availability of sale of such similar goods, the value at different commercial level with different quantities can be concerned for such valuation provided the differential attributable to commercial level and or the quantity shall be used. Such adjustments can be provided on the basis of evidences clearly depicting the reasonableness and accuracy of the adjustment. For the applicability of this method, two or more transactions of similar goods are required to be identified and the lowest such values shall be adopted for deciding the transaction value of goods imported. Next, deductive value. The agreement provides that when customs value of imported goods cannot be determined at transaction value or identical goods or similar goods, it will be analyzed on the basis of unit price at which the import of identical or similar goods take place with unrelated buyer at greatest aggregate quantity in the country of importation. While implementing such measure, both the parties, that is the buyer and seller, must not be related to each other and the sale must take place at the time of importation of goods being valued. However, if no sale is found or at the time of importation it is permitted to use sales up to 90 days after importation of the goods being valued. According to the article, the price can be determined at that point where greatest number of quantity is sold to unrelated person at the first commercial level at which such sales take place. The greatest aggregate quantity can be ascertained by taking the sum of all units sold at given price and then compared to the sum of all units of good sold at any other price. The greatest number of units sold at one price would be the greatest aggregate quantity. Certain deductions from the price at greatest aggregate quantity has been outlined in the agreement as the sale price taken to calculate the transaction value is the sale price in the country who have imported the goods from other country. These deductions are commissions, general expenses, sum of profits, transport cost, insurance, customs duties, other national taxes, value added by assembly or further processing when applicable are required to be deducted as these expenses are incurred within the country of importation. Next, computed value. As per the agreement, where the seller is the actual manufacturer of the goods sold and has access to all the information of production to determine the value of goods imported, the computed value method is used. The custom value under the method is ascertained by taking the sum of the following elements: the value of the raw materials and fabrications or other processing employed in manufacturing the goods, the amount of profit and general expenses usually reflected in export sales, the direct and indirect cost of production and selling the goods for exporting, transportation, loading, unloading, handling charges, cost of container and packing, and insurance of the imported goods. Next, fallback method. This method is used in exception circumstances where it becomes impossible to ascertain the customs value of imported goods under any of the foregoing valuation methods. Under such situation, a flexible approach is applied where most readily method enables the circulation of the customs value. It is expected that the customs value arrived at must be fair, uniform, reasonable and neutral, reflecting the commercial reality to the maximum extent. Under fallback method, the customs value should not be based on the following: fixation of customs value on the basis of the selling price or sale price of goods manufacturers in the importing country, on a system which specifies the adoption of higher of the two alternative values, the lowest will be adopted, the price of goods prevailing in the domestic market of exporting country, on the cost of production other than computed values determined for identical similar goods, adoption of price of goods exported to third countries, minimum customs value exception in case of developing countries if accepted, arbitrary or fictitious values. We shall understand the special and different treatment for developing countries. The agreement permits the developing country members to delay the applications of the provision of the agreement for a period of 5 years from their date of entry to WTO agreement, Article 20.1. Also, following the application of all the provisions of the agreement, the developing country members have been given the delay of 3 more years to the application of computed value method, Article 20.2. In a nutshell, developing country members can delay the adoption of computed value method of customs valuation till a total of 8 years. Moreover, the developing country members may be given extension for the application of the provision of the agreement on sympathetic consideration on request before expiry of 5 years extension as per para 1 of annexure 3rd of the agreement. The right to value the goods on deductive method even if the goods have gone further processing at importing country, whether or not importer makes request, has been given to the developing country member to ascertain customs value, para 4 of annexure 3rd. The provisions of technical assistance on request has also been made for helping the developing countries by the developed countries to implement the agreement, Article 20.3. Now, moving on to customs valuation in India. The British firstly codified the provisions of levying the customs duty in India in 1878 by introducing the Sea Customs Act 1878. The valuation of goods were based on real value that was defined by section 30 of the Act as wholesale price less trade discount and import duties or capable of being sold in same quantity at the time and place of importation. With the growth of trade and increase in number of transactions and products traded, the valuation of customs duty on the basis of real value started creating problems, especially in case of interpretation of terms, wholesale price and capable of being sold. With due consideration to the provisions of GATT Article 7th and the growing domestic demand, a new Customs Act 1962 was enacted, replacing the old Sea Customs Act 1878. The Customs Act 1962, under its section 14, provides the valuation of goods as the ordinary selling price of goods or like goods or offered for sale for delivery at the time and place of importation where buyer and sellers are not related with each other. India signed the Agreement of Customs Valuation in 1980 and availed the extension of 5 years and then 2 years as per Article 20 of the agreement to implement and adjust the changes in its system of levying customs duties. India has been following the provision of WTO Agreement on Customs Valuation since 1988. Section 14 of the Act was amended to include a new subsection 14, subsection 1A, to insert the adjustment for determining the price of imported goods in accordance with the rules of the agreement. Then, the Customs Valuation Department of Price of Imported Goods Rules 1988 were notified that consist of majorly all the substantive provisions of the Agreement of Customs Valuation. In practice, the valuation of the goods till 2007 were being valued according to the deemed concept as specified in Section 14 of the Customs Act 1962, where the Supreme Court of India in one of the cases held the application of Agreement on Customs Valuation rules right. Rule 10A of the Customs Act 1962 allows the authorities to reject the transaction value in case of suspected valuation fraud. In these cases, the customs could ask the importers to provide the further details to justify the declared value. If the importer fails to justify or the details further submitted were not satisfactory, the customs could reject the declared value and appealable order should be issued after giving reasonable opportunity to be heard. Then the goods are to be valued as per the rules defined. Presently, the National Import Database facilitates reliable tool for comparing declared values with contemporaneous import prices. It is updated weekly and made available to all customs stations on www.dov.gov.in. Now we understand the dispute settlement. Under the WTO agreement, all the members have agreed that if they found other members are violating trade rules or commitment or agreement, they will follow the multilateral system of settling dispute instead of taking action independently. This indicates that the WTO members are abided by the agreed procedures under understanding on rules and procedures governing the settlement of disputes and respect rulings. However, passing the judgment is not the motive of WTO, but to resolve the matter through consultations if possible. Normally, a dispute arises when one member implements a trade policy or takes an action that one or more other fellow members of WTO think it to be in contravention to the existing agreement or to be a failure to live up to obligations. A dispute resolving mechanism existed under the old GATT, but it suffered certain limitations like no fixed time frame for resolving matter. Ruling were easier to challenge and matter dragged for a longer time inconclusively. The Uruguay Route Agreement outlined a more structured mechanism with more clarity, defining the stages in the procedure to resolve the dispute between the member countries. It describes the fixed time framework under which the case is to be settled in a disciplined way, with flexible deadlines set in various stages of the procedure. It outlined the detailed procedure and timetable to be followed in settling the conflict. If a case runs to its one go, it will not take more than 1 year, and if appealed, then 15 months. These time limits are flexible in nature if there is a case of urgency. For example, if perishable goods are involved, then it is expedited as much as possible. Under the previous GATT procedures, the ruling could only be adopted by consensus. It means that if there is a single dissent, the ruling could be blocked. The Uruguay Round Agreement made it impossible for the losing country to block the adoption of the ruling. Now, rulings are adopted automatically unless there is a consensus to reject the ruling. It means that if any country wishes to block a ruling, it has to persuade all the members of WTO to share its view. Since the system seems to be much resembling the proceeding of a court or tribunal, the preferred solution for the countries is to discuss their problems and settle the dispute individually under this platform. Next is procedure of settling dispute. The disputes are settled by the dispute settlement body consisting of all WTO members. It has powers to make panels of experts to examine the case and accept, reject the findings of the panel or the result of an appeal. It emphasizes on the enforcement of the rulings and recommendations to be implemented. It also has the power to authorize retaliation when a member country refuses to comply with the ruling. The dispute process takes the following stages. First stage, The concerned countries under dispute are given chance to consult each other and settle their differences by themselves up to 60 days. If the solution through consultation fails, they can refer the matter to WTO Director General to mediate or make an effort to resolve the dispute in any other way. Second stage, if the consultation fails, the complaining country can demand for a panel to be appointed. The panel is appointed within 45 days and it takes another 6 months to conclude its report. The formation of the panel can be blocked by the country in the dock, but such formation of a panel can no longer be blocked at the second meeting of dispute settlement body unless there is consensus against forming the panel. If the dispute is related with developed and developing country, at least one panelist shall be from the developing country if requested. If there is no agreement on the panelist within 20 days after the panel establishment, the chairman of DSP on request should intimate the members regarding the composition of panel not later than 10 days after receiving such request. The term of reference, that is the description of the conflict, citing the relevant provisions and agreements etc. in consultation with the parties concerned, is prepared and circulated among the conflicting parties within 20 days from the establishment of the panel. The parties other than disputed parties who have concern with the outcome of the decision of the conflict are termed as third party. The panel can meet with the third parties to discuss the issue under its examination. The panel normally meets the conflicting parties twice or more during its examination. After receiving the comments or replies from the parties and following the consideration of rebutable submission and oral arguments, the panel shall prepare its interim report with full confidentiality and without the presence of the parties concerned. Then, the interim report is to be sent to the parties concerned for their comments. If there is any comment to be discussed, the panel can fix a meeting with the party to discuss such comment and review it. This process is to be completed within 6 months from the establishment of the panel. If no comment received within the comment period, the interim report is to be considered as final report and circulated to the parties concerned up to 9 months from panel's establishment. Within 60 days after the date of circulation of panel report to the members, the report is to be adopted by the DSB unless the party to dispute notifies the DSB of its decision to appeal. If party notifies appeal, the report cannot be adopted by DSB until after completion of the appeal. The dispute settlement body shall constitute a standing appellate body which will hear the appeals from panel cases. As a general rule, the proceedings of the appellate body shall not exceed 60 days from the date of its appeal to DSP. The appellate body shall address each of the issues raised in its proceedings and may uphold, modify or reverse the legal findings and conclusions of the panel. Then the DSP adopt the report usually up to 9 months with no appeal or 12 months with appeal from the establishment of panel. At a meeting of DSP held within 30 days after the adoption of the panel or appellate body report, the member concerned will report to the DSP about its intention to implement the decision, or if it is impractical to comply immediately, it shall have a reasonable period of time to implement the decision. The reasonable time shall be the period proposed by the member concerned or mutually agreed period or a period determined through arbitration within 90 days after the date of adoption of recommendations and rulings. If it fails to act within this period, it has to make negotiations with the complaining country or countries in order to settle mutually acceptable compensation such as tariff reductions in areas of particular interest to the complaining side. In case no agreement on compensation is agreed upon, after 20 days, the complaining member can request the DSB to retaliate to suspend concessions or other obligations. Such clause is inserted to encourage the member countries to comply with the recommendation for the enforcement of the decision of the DSP. It could, for example, initiate the step of blocking imports by increasing import duties on products from the other country above agreed limits to levels so high that the imports are too expensive to sell within certain limits. The DSP must authorize this within 30 days after the reasonable period of time comes to an end unless there is a consensus against the request. In principle, the retaliation should be from the same sector of the dispute and may shift to other sectors of the agreement if such retaliation of same sector is not practical to impose or become ineffective. If shifting retaliation to other sector has also become ineffective, it can be shifted to other agreements if the circumstances are serious in nature. The main objective is to minimize the likelihood of actions shifting to unrelated sectors while at the same time efforts are made to enforce the actions effectively. Let us now recapitulate what we have studied so far. Custom valuation is the process where customs duties are levied by the customs authorities on the value of goods or services imported. Developing country members can delay the adoption of computed value method of customs valuation till a total of 8 years. Moreover, the developing country members may be given extension for the application of the provision of the agreement on systematic consideration on request before expiry of 5 years extension. The valuation of goods were based on real value that was defined by section 30 of the Act as wholesale price less trade discount and import duties or capable of being sold in same quantity at the time and place of importation. With the growth of trade and increase in number of transactions and products traded, the valuation of customs duty on the basis of real value started creating problems, especially in case of interpretation of terms wholesale price and capable of being sold. This indicates that the WTO members are abided by the agreed procedures under understanding on rules and procedures governing the settlement of disputes and respect rulings. However, passing the judgments is not the motive of WTO, but to resolve the matter through consultations if possible. Thank you.